It's Wednesday, it's 10 o'clock. Welcome to the Hill Dickinson Autumn Real Estate Update 2025. It's exciting times here at Hill Dickinson. The firm is continuing to grow. We've seen growth across all practice areas and locations. In real estate, since we last met in spring, that has seen us appoint several key new strategic lateral hires and several internal promotions. Most notably, the arrival of the incredibly talented and experienced Keith Barnett as our new head of London real estate. We've also seen the Manchester team move over the summer into fabulous new offices at number 1 St Michael's. And of course, most of you would have seen Hill Dickinson announced as the naming rights partner for the fantastic new football stadium for Everton Football Club, which I had the privilege to be at on Monday night. I saw my beloved West Ham become the first away team to score a goal at the new stadium in a competitive match. Bringing it back to this morning, once again, we've had the best part of 500 people register for today's updates. We'd like to thank you all for taking time out of your busy schedules to join us today, and I know you will not be disappointed. Following our established format, we have 3 speakers for you this morning. In a few minutes' time, I'll kick off with my news at 10 a.m, a roundup of impending and proposed changes to real estate legislation. I will then hand over to James McHugh from our real estate litigation team, and we'll move from legislation to case law as James reviews some significant recent landlord and tenant cases, including the London Trocadero case on the recoverability of insurance premiums under commercial leases. And then finally, I'm very excited to present our competition law guru, Mr. Jay Mehta, who will be exploring trigger points where competition law issues can arise, often quite unexpectedly, in real estate transactions. Now, I'll let you all read the housekeeping slide yourself. As always, I would recommend that you drop questions into the Q&A box as they occur to you, and I will ask as many of these questions as time permits once all 3 speakers have finished. You can also download a copy of the slideshow if you wish. We'll make sure we have you on your way by 11:30, and we'd really appreciate it if, when you leave, you could answer the brief feedback survey that will appear. So, without further ado, here is the news. Ping pong pain. Why has the Renters' Rights Bill still not been passed? What goes up might be coming down. Upwards-only rent reviews under threat. Dead and buried? Is the end finally nigh for chancel repair liability? Hot property. The Law Commission is to review another set of real estate-related legislation. Weighing your options. Is the Contractual Controls Register finally about to happen? And finally, what to expect from Rachel Reeves' autumn budget. So I talked about the Renters' Rights Bill at the spring update. This is a wide-ranging bill which will radically change the law relating to residential tenancies. There'll be no more fixed-term assured tenancies, no more assured short-term tenancies, no more no-fault eviction under Section 21. But the Act goes far beyond that. It will affect the ability of landlords to increase the rent, the tenant's right to keep a pet, the decent home standard, AWAB's law, greater enforcement, etc., etc., etc. As I said, we talked about it in spring, but the big question is, why has it not become law yet? So I said in the spring that we expected it to join the statute book before the summer recess, but it didn't quite get there. The bill completed passage through the House of Commons and the House of Lords, but had to wait until Parliament resumed in September before the ping-pong process could start, whereby it shuttles back and forth between the Commons and the Lords until it's finally agreed. I think the government had hoped it would be passed before the Labour Party conference, but it's not quite there yet, and it's due back in the House of Lords on the 14th October. but it will become an act. It will become law relatively soon. But that doesn't mean everything will change immediately. Most of the big ticket provisions require secondary legislation and consultation. The government has said it will give the sector fair warning before anything is introduced. The government has also said that they will not be publishing their implementation timetable until after the bill gets royal assent and becomes an act. So I think it's probably fair to say it is incredibly unlikely that these big ticket changes will take place in this calendar year. But the smart money is on the changes, the move towards assured periodic tenancies and the abolition of no-fault eviction, likely to take place within the first half of 2026. One change to note since the spring update affecting the student market, and the government has announced that the PBSA sector, so purpose-built student accommodation, will be excluded from the new regime, so will therefore presumably be able to continue to grant fixed-term tenancies, subject to the operator being part of a government-approved code of practice. But we need to see the precise wording of this exclusion in due course. And on the residential side, we're also awaiting implementation of the remaining provisions of the Leasehold and Freehold Reform Act 2024. And also the government has confirmed in the last few days that the draft Common Hold Bill and related consultation is still on course to be published before the end of this year. Moving from residential tenancies to business tenancies, I think it's fair to say that the proposed ban on upwards-only rent reviews came as a bit of a shock. So the English Devolution and Community Empowerment Bill was introduced into Parliament on the 10th of July. It's a massive bill, over 300 pages, dealing mostly with local government issues. But tacked on the end in the final schedule, Schedule 31, are provisions to be inserted into the Landlord and Tenant Act 1954, banning upwards-only rent reviews in new business tenancies. And that will apply regardless of whether the rent review is linked to open market rent, inflation, or turnover. Few things to comment on the bill as introduced into Parliament. One, although it's being widely touted as a ban on upwards-only rent review clauses, it doesn't say you cannot put an upwards-only rent review clause in a lease. It simply nullifies it. If there is an upwards-only rent review clause, it is ignored for the purposes of calculating the rent. And landlords may still choose to include an upwards-only rent review clause for reasons that may become more apparent in a minute. Next thing to note, this will only apply to new tenancies. So existing leases with upwards-only rent review clauses are unaffected. Contrast that, for example, with Renters' Rights Bill, which will convert existing residential tenancies into the new periodic assured tenancies. So upwards-only rent reviews will only apply to new tenancies. It also only applies to business tenancies within Part 2 of the Landlord and Tenant Act 1954. Does that include, for example, leases which are contracted out of the security of tenure provisions of the 1954 Act? Well, yes, it will capture them, because although they are contracted out of security of tenure, they are still business tenancies within Part 2. However, to be a business tenancy within Part 2, the tenant must be in occupation for business purposes. So a tenant who has vacated the premises, a tenant who has sublet, will not enjoy the protection being proposed by these new provisions. And you may therefore end up in a situation where a tenant has sublet and an identical rent review clause in the head lease and in the sublease operates differently. Because in the sublease, the upwards only aspect is ignored, but it is not ignored in the head lease because the tenant is not under the head lease, is not in occupation, and it is therefore not a business tenancy. Now, the bill also gives tenants the power to trigger a rent review and to take other action necessary to progress the rent review to a conclusion. So, in leases where those powers are reserved exclusively to the landlord, and tenants have therefore historically been unable to force matters through, they will now be able to do so under these proposals. Now, those of us of a certain vintage will recall previous proposals to ban upwards-only rent reviews, but I don't think it's ever got this far before, in the sense of a bill progressing through Parliament. So we have to assume that this time it may finally happen. But there is a long way to go yet. So this is a chunky bill currently going through committee stage in the House of Commons, but certainly one to keep an eye on. Now, if you own a property, residential or commercial, within a parish which has a pre-Reformation Anglican church, it's possible that you may be responsible to pay for repairs to the chancel of the church. Now, until 2013, chancel repair liability was an overriding interest. It ran with the land and bound successive owners, regardless of whether there was any mention of it on the title, regardless of whether anyone was aware of any actual liability. Hence, the practice evolved of carrying out a chancel search, and if the property was perceived to be at risk, effecting insurance against any chancel repair liability. Now, in 2013, at the end of a 10-year run-off period commenced under the Land Registration Act of 2002, chancel repair liability lost its overriding interest status, and that was supposed to be largely the end of the matter. However, uncertainty remained as to the precise effect of the legislation and also as to the nature of chancel repair liability. Is it even an interest subject to the land registration process at all? So as a result, we didn't get to say goodbye to chancel repair searches and chancel insurance. So the Law Commission in July has launched a new consultation to remove the uncertainty that has persisted since 2013, they say, by clarifying with retrospective effect that a purchaser cannot be bound by chancel repair liability unless it is protected by a notice on the title. All very well intentioned. My initial view reading the proposed legislative changes to the Land Registration Act 2002 are that I'm not 100% convinced that it goes far enough. Does it entirely remove all the uncertainty? Does it give everyone sufficient comfort that we can proceed without searches, without insurance? The proposed change sort of tinkers with existing land registration concepts. Is it time now, 20 odd years since the Land Registration Act 2002 called the last orders on chancel repair liability, is it time to say, right, if you haven't registered it by now or by a certain date to be set in the Act, that any chancel repair liability for that property is extinguished for that property, for all owners, current and future, for all purposes, forever. So the consultation runs until November, so it'll be interesting to see where it ends up. And also, of course, as with all consultations, it will then be dependent on a government having sufficient interest to actually implement whatever change is recommended by the Law Commission. And while we're talking about the Law Commission, I mentioned in the spring update that the Law Commission was consulting on the Landlord and Tenant Act 1954. You'll recall that under that act, a tenant who is in occupation for business purposes enjoys statutory rights, including security of tenure and the right to renew, unless the lease has been contracted out of those statutory rights. And James, in his section, will be looking at some recent cases dealing with lease renewals under the Landlord and Tenant Act 1954. I mentioned in spring the Law Commission was carrying out a consultation considering all options, ranging from all leases having security of tenure with no ability to contract out, through to no leases having security of tenure at all. Since spring, the Law Commission published its interim statement in June. Their provisional conclusion is to preserve the status quo, that leases should remain having these statutory protections unless the landlord-tenant agree to contract out. There will now be a second stage to the consultation, looking at how we can improve the existing process, both in terms of improving the lease renewal process itself and the issues that arise under it, but also improving the contracting out procedure. Probably the most significant proposal in the Law Commission's provisional conclusions is a suggestion that leases up to 2 years in length should not enjoy statutory protection. Currently, the threshold is 6 months. Leases up to 6 months do not get protection. Leases over 6 months do. Proposal to extend that threshold to 2 years, so leases up to 2 years would not be protected under the Act. And while we're talking about the Law Commission, they have just published in September their 14th programme of law reform. Every so often, the Law Commission publishes a programme listing the areas of law they intend to investigate over the coming years. The previous one was published in 2017. So the next programme includes a number of real estate issues, and particularly some real estate statutes that the Law Commission intends to investigate. But I said these are things they're going to look at over the coming years. So we can expect to see consultations in due course, but these are more medium to long-term issues where nothing is going to change imminently. But it's good to see that they are going to look at the Landlord and Tenant Covenants Act 1995 to do with lease assignments and authorised guarantee agreements, and also the right of first refusal under the Landlord and Tenant Act 1987, insofar as it affects commercial leases and therefore sort of mixed use premises. Now, I mentioned the Levelling Up and Regeneration Act 2023 in the spring update, but at that point I was looking at the context of Part 10 and the introduction of high street rental auctions. And as a side point, I've still not seen that any high street rental auction has actually happened yet, although I'm aware of a number of local authorities who have been busy designating qualifying high street and town centre areas where those powers may be applied in due course. I'm looking today at Part 11 of that Act, which provides for a register of third-party contractual controls over the development, use or disposal of land in England and Wales. Now, the previous government consulted in January 2024 on what this might look like. And obviously that went quiet with the general election, and this was another area that we wondered whether it would just fade away with the change of government. But a bit like high street rental auctions, it appears that the Labour government is intending to adopt it. So this year we have seen the government's policy paper Speeding Up Build Out, which confirms the government's intention to make contractual control agreements more transparent. There's also a letter from the relevant minister, Matthew Pennycook, to the Land Registry, suggesting that this register may launch or will launch in 2026. So what exactly are we talking about in terms of contractual controls? Well, if the proposals were to go ahead as per the January 2024 consultation, we're looking at a register to be maintained by the Land Registry and therefore sit alongside the main title register. The 2024 consultation said that they would be looking to include option agreements, conditional contracts, preemption rights, promotion agreements, but not restrictive covenants or overage agreements or clawback agreements. So there will be further discussion, probably further consultation, but one to keep an eye on, particularly for developers who may have the benefit or may be seeking to take the benefit of option agreements, conditional contracts, etc. And then finally, the autumn budget has been confirmed now for the 26th of November, so perhaps slightly later than we might have expected. I'm not foolish enough to make any predictions as to what the budget will include, but obviously we always keep a close eye on it, particularly as real estate folk. We're interested in things such as changes to stamp duty land tax, SDLT. Will the government honour its manifesto pledge to increase the surcharge for overseas buyers, for example, or is that now sort of been overtaken by events? There's been a lot of talk about the government considering replacing SDLT altogether with a national property tax. I suspect that would be too bold a move for the government to launch in this budget, but we may see a commitment to exploring that further. There's talk of a possible targeting of high value homes, either through reforms to the council tax mechanisms or through possibly perhaps removing private residence relief from capital gains tax for homes above a certain limit. There's been talk of increasing the income tax, and particularly the national insurance burden on landlords, and possibly changes to inheritance tax that may impact upon real estate. So, as always, we have to wait and see. As we get closer to the event, we may get more of a feel for what's likely to happen. If anyone is feeling brave and would like to put their budget predictions in the Q&A box, or perhaps what you would like to see in the budget in the Q&A box, then we can pick up some of those at the end. Right, so that's me done, and I would now like to hand you over to James McHugh for his real estate litigation update. So over to you, James.
Thanks, Bill, and good morning, everybody. Thank you for joining us this morning, giving me the opportunity to discuss case law updates with you. You recall in the spring there was plenty to talk about in respect of the 1954 Act, and that remains the case. So what we're going to cover in the next 20 minutes or so is the first one was one I discussed in spring, MVL Properties and the Lead Mill. It relates to Ground G. Does it infringe on a tenant's human rights? The answer in that case was no, but the tenant did appeal, so I'll update you on that. Next, we're going to cover London Trocadero and Picture House Cinemas Limited. This was quite a well-publicised decision relating to insurance premiums. Are they always recoverable from a tenant? We'll find out in the next 10 minutes or so. Then Spirit Pub Company in Pridewell, Ground F, so that's the redevelopment ground. It's a very good case outlining all the points landlords need to prove and things tenants can do to frustrate that. So I'm going to go through that in a bit more detail. And then finally, which is unusual for these sorts of things in landlord and tenant anyway, we're going for a quick dalliance in telecoms land. There are two decisions recently that have general landlord and tenant points, and I thought I'd point them out to everybody. So without further ado, MVL Properties and the Lead Mill. So you'll recall from the spring update, it was a Ground G opposition, i.e. the landlord intends to go into occupation of the premises and run a business from there itself. Tenant opposed on a number of grounds, but the most interesting ground was that it breached its human rights, Article 1, Protocol 1, i.e. it was going to deprive the tenant of its possessions. The argument ran was that the landlord was effectively going to go in and run the same business, therefore all goodwill, etc., that the lead mill had built would be acquired by the landlord for free. As you can see, is that the High Court said goodwill can be a possession, but A, the tenant needs to prove it, and in any event, the 1954 Act is compatible with human rights as it stands. So it strikes a fair balance between landlord and tenant property rights. There are various checks and balances in there. So the final nail in the coffin was it's not in the public interest to prevent a landlord from recovering his property. So update on the appeal, quite short really. Permission to appeal was refused by Lord Justice Lewison. So the decision stands. Ground G of the 1954 Act is compatible with the European Convention on Human Rights. We'll all be glad to hear. So you can see there, that's the final statement from the lead mill upon closing. They really did, it was a good effort, to say the least. That the human rights element was the first time I'd seen that sort of argument run in the context of lease renewals. And the picture there on screen is from the last ever gig at the lead mill. It's on the 28th of June. That was Miles Kane, so that could probably be useful for any pub trivia in the future. The same takeaways as in spring. Remember what a lease is. It's a term of years absolute. If you're building a business based primarily on your location, your business, ideally you'd like to acquire the freehold at some point if possible. Tenant did have that opportunity here 10 years ago, ultimately couldn't agree terms. And the second point, keep track who has the reversionary interest. MVL Properties, they run business venues, music venues up and down country. That is their business model. So when they acquired this interest, the writing was on the wall. And finally, respect the embargo. I'll always bang on about that. Do not release details of a judgment before it's been handed down by the court. Quite a serious offence for lawyers, so I think I'm doing all my colleagues a favour by reminding everybody of that. So, onto the new stuff. London Trocadero and Picture House cinemas. So, London Trocadero are part of the Criterion Group. They are a huge landlord in London, central London specifically. They have a almost £4 billion portfolio. If you've walked across Leicester Square area, you've likely walked within their estate. Picture House Cinemas, as you can see from the image there, Cineworld is one of their brands, and this is the latest instalment in long-running litigation between the parties. There was lots of cases in 2020 and 21 regarding COVID rent arrears and whether or not you could forfeit the lease, etc. But this decision deals with a number of points: service charge, repairs, etc. But I'm going to focus on the insurance element, specifically the landlord commissions, which was a term the judge coined in the decision. Commissions in respect of placing insurance are commonplace. They have been for a long time. It's designed to compensate the broker for the costs of sourcing the client, getting the information, liaising with the insurer, the client, checking policy documents, handling any claims. So the heavily inflated commission, there was an agreement between the landlord and the broker to pass on the inflated element to the landlord. So the result was insurers still get the same premium they always would. The brokers still got the same remuneration they always would. But tenants would end up paying more for the same insurance, leaving the landlord to pocket the commission for not really doing any additional work. This practice, particularly based on the evidence in this case, it is widespread. It's not just an isolated incident. And on the screen there, I've included the relevant clause from the lease. So the 1994 lease is what Cineworld occupied the unit under. And the relevant part of the insurance element is that tenant is to pay a proportionate part of the total sum payable by way of premium for keeping the centre insured. So what did the court find? Of course, it was not contractually entitled to recover landlord commissions in this matter. The decision is lengthy. It runs 350 paragraphs. So if you do want to do a bit of light reading, this issue was referred to as the premium issue in the decision. The key finding is at paragraph 85. The landlord would have been able to obtain the same level of insurance cover without the landlord's commission element. If we go back to the clause very briefly, the landlord could only recover the sum payable by way of a premium for keeping the centre insured. The commission had nothing to do with the insurance bit. The commission was just that, it was just commission. Neither the landlord or any member of its group company had done any additional work for that. Therefore, the inflated commissions didn't represent an appropriate reward for the landlord for arranging the insurance. That was the broker's job. So based on that clause, the tenant was successful. Tenant's claim in restitution was successful, so the tenant had paid these sums already and was entitled to claw them back. They succeeded on what's known as a total failure of basis type claim. So it was never justifiable for the landlord to claim the commission elements based on that clause in the lease, because there was no contractual basis to do so. And as you'll see, I've included a table of the figures we were talking about. They are quite significant. The landlord here must repay the tenant in the region of £640,000. So what I want people to take away from that is check your leases, landlords and tenants, have a look. The specific wording in this case will definitely be less widespread than most people expected at the time. And most modern lease precedents do include recovery of a premium, but there will be leases out there that don't permit that. Say tenants, landlords, have a look, see what you've been paying, and ask questions. Tenants ask for some visibility on the portfolio, ask what the insurance is, what element was commission. Same for landlords. I think transparency is key if you want to avoid being inundated in these sorts of requests. And specifically for tenants, if there's any doubt, pay on the protest. That's what the tenant did here. They use sort of protest wording, that sort of without prejudice to the right to claim back, that sort of wording. Pay now, argue later has been endorsed by the Supreme Court in service charge disputes. It was this Blacks Holdings and Sarah Hussein case recently. So adopting a similar approach here will protect you from enforcement action from landlords. I can't sort of sensibly suggest you just withhold the monies, because landlords will be entitled to pursue you under sort of various other enforcement options. That takes us to Spirit Pub Company and Private Properties, so back to lease renewals. This one is ground F, so probably the more common opposed lease renewal you'll find. It's to do with redevelopment of the holding by the landlord. I covered what the holding was in detail in the spring update, dealing with the case of Sainsbury's and Medley Assets, so you can catch back up on that if you want discussion on what the holding means. But ground F, it says the wording in the statute is the landlord intends to demolish or reconstruct the premises or carry out substantial work of construction on the holding and cannot reasonably do so without obtaining possession. So effectively, the landlord wants to redevelop and it can't build around the tenant, so the tenant needs to get out. So the landlord here is a family property company. They specifically bought the freehold of the Railway Bell pub, which you can see on the slide, with a view to demolishing the pub and rebuilding some new houses and flats. It'd still be a pub on site, but it'd be considerably smaller. It'd just be the ground floor and a beer garden, which would be less than 50% of its current size. The landlord on this matter did provide objective intention of its intention to redevelop. They bought it specifically with the intention to redevelop. That's what they said in their witness evidence. They sought pre-application advice from the planning authority. As long as a year before the tenant had even served its Section 26 notice, they were already engaging with the local authority in terms of planning permissions. The local authority had confirmed it'd be minded to grant permission subject to some surveys being undertaken. The landlord had managed to undertake the vast majority of those surveys in respect of there was a bat survey, there was all the sorts of property type surveys you need to undertake, but crucially, the local authority also requested an acoustic survey in terms of residential property being so close to a pub. You need various acoustic elements to avoid any noise nuisance. The tenant refused access in respect of those surveys. Based on the current tenancy, the landlord's right of access related to going in to undertake repairs. Intrusive surveys were not really covered by that. So the tenant was well within its rights to refuse the landlord access on that point. So the landlord couldn't undertake the survey and therefore couldn't get the planning permission prior to the hearing. This ultimately has an unfortunate knock-on effect for the landlord, as we'll see on the next page. But without the acoustic survey, it couldn't secure planning permission. And without planning permission, it wouldn't be able to get a firm commitment from its existing lender to fund the development. So, as ever with ground F cases, the court has to assess whether or not the landlord has a firm and settled intention and a realistic prospect of overcoming any practical hurdles within a reasonable time after the lease in order to do so. So as we covered, the court did accept that this landlord had intention. Genuine and settled intention is the phraseology from the case of Francis and Cavendish. There's also a lovely judicial turn of phrase of going out of the zone of contemplation into the valley of decision. The court on this matter accepted that the landlord did have the requisite intention to redevelop. What they didn't have were all the things in place. So the works were substantial and possession was required. One of the arguments the tenant ran is they could do the works around them, but that quite frankly wasn't feasible. So in terms of the hurdles that the landlord had to overcome, first there was the planning issue, which we've covered. They'd done everything they ostensibly could to get planning permission. We fell down on this acoustic survey, but on the evidence, the court accepted that the landlord had done everything it could, and on balance, subject to getting an acoustic survey, would have a better than 50% chance of getting planning permission. So they ticked that box. There was also a restrictive covenant in the freehold interest. It was quite a dated restrictive covenant. The decision doesn't go into it in too much detail. But the court again was satisfied that the landlord would get over the restrictive covenant, get it amended or removed. But the final hurdle was financing the development. And ultimately the landlord fell at that hurdle. So although they had funding in principle from an existing lender, subject to planning permission being granted, because it was a small family company run by three brothers, all directors, all shareholders, the directors were likely to have been required to be give personal guarantees to the lender. One of them had. The other two, there was no evidence before the court that they would give personal guarantees. There was no evidence of the financial standing of the directors or the shareholders. So that being the case, unfortunately, the judge found that the landlord had failed to prove that funding was in place and would be in place, and therefore the landlord failed to get over the final hurdle and failed to satisfy ground F based solely on that ground. One interesting point that came out of the decision was also time for commencement. So on the evidence of this case, the landlord wouldn't be starting works 14 months from the date they got possession, based on obviously the time it takes to finalise planning permission and remove the restrictive covenant. And based on previous cases, that's significantly longer than what's known as the 3-month statutory tolerance. And it's even longer than 12 months in the key case Francis and Cavendish. But the judge adopted a relatively pragmatic stance and said the landlord had done everything reasonably expected of it to progress matters. So on the facts of this matter, 14 months was reasonable. So it's difficult not to feel a measure of sympathy for the landlord. They had financing in principle, but obviously that's not contractually binding. They'd amended planning permission and we're quite close to getting that too. The only reason we couldn't get it is because the tenant refused access for acoustic tests, but ultimately it's on the landlord to make sure by the date of the hearing they have everything covered to the extent they can. The judge felt that obtaining evidence from all directors that they would give personal guarantees and evidence of their own financial standing was quite easy for the landlord to obtain, and failure to do so was fatal. So landlords, make sure you have everything covered to the extent you can. Intention, plans, finances, check your evidence, check it again, particularly as you get close to your hearing, because the hearing date is the date you need to prove that you have everything in place in order to satisfy the court that you're going to be successful. Tenants, on the other hand, don't assume a landlord redevelopment plan is bulletproof. If it's a good site for you, if it's a good store in your retail portfolio, or for one reason or another, ask the landlord for evidence. Ask for evidence of funding. Ask for any planning permissions. Ask for any timelines. Ask for any resolutions of directors to confirm intention. And if that doesn't stack up, or it looks uncertain or conditional, challenge your landlord. The court's focus is on substance over aspiration. So if the plans aren't firm, you might be able to challenge them. You don't have to take it to trial. You could use it to get a better deal on renewal. reduced rent in return for a landlord break, a redevelopment break, get yourself a sort of guaranteed minimum term. There's a couple of ways you could play it. As you'll see there at the bottom, permission to appeal has been granted, so stay tuned. The landlord might be able to get over that final hurdle on appeal, but we'll see. And finally, into telecoms. So I'm not going to go into detail on the telecoms elements of these matters. And I'm going to focus on the sort of the core issues that are relevant for sort of all landlord and tenant type matters. But this first decision, AP Wireless 2 Limited and On Tower, deals with certainty of term. So on the screen there, that is how long that was the term of this agreement. It continued for the minimum term. The minimum term was 10 years from March 97, and it may be terminated at not less than 12 months at any time after the minimum term. Is that clear enough? So both the tribunal and the upper tribunal said no, the agreement lacked fundamental ingredients of a lease, which is certainty of term, based on the way it's expressed in that clause. It's neither a fixed term or a periodic term or a combination of the two. Therefore, in order to give effect to the agreement, it's only logical that it takes effect as a license. And that's important because licenses are obviously excluded from the 54 Act. They don't have security of tenure. At a very basic level, renewals for telecoms leases under the 1954 Act, so older agreements like this agreement, are more site provider friendly, usually have a higher rent and less sort of operator friendly clauses in there. Whereas operators like to use the Electronic Communications Code because it's the opposite. It's very operator friendly. There's lots of wide ranging powers. So most operators like to renew under the new law. So this was taken to the Court of Appeal to see whether or not the tribunal was right. And yes, is the short answer. The Court of Appeal agreed. I've repeated the classic Street and Mountford principles of what a lease needs: exclusive possession for a term certain in exchange for a rent, although rent's not strictly necessary as it says on the slide. As at the date the parties signed that agreement, it was not clear how long the term was, and that's the crucial factor. It was clear and it's got to be clear and unambiguous, and that clause is not. It's a 10-year minimum term on 12 months termination notice, but what is the date it is going to end? There's no certainty for either party upon signing of the agreement. So absent that, the court has to look into what the parties intended at the date the lease was granted. Ultimately, in order to give effect to what the parties intended and give effect to the remainder of the agreement, it made more sense for it to be a contractual license. And that's only a personal right to occupy. It's not a legal estate. Ultimately, it doesn't have security of tenure under the 1954 Act. So takeaway, make sure you know what you're entering into. It sounds sort of very trite, but check the term. Is it certain? If it's not, you could find yourself in trouble when you're trying to renew your lease. Equally, the flip side, if the intention is for it to be a license, avoid lease style wording, certainly avoid exclusive possession of the area, and always consider what the position is on the ground. Even though the agreement might say it's a license, if it grants exclusive possession for a fixed term and a payment of rent, it could be a lease. The courts look into the reality of the arrangement, not just the wording and not just what the parties say it is. So you just have to make sure you know what you're entering into. And finally, this telecoms matter. So there's a nice picture of Saddleworth Golf Club, which was one of the agreements that was subject to this decision. This decision covered 4 or 5 tenancies in one, and it all deals with contracting out of the 1954 Act. Has it been done properly in all these matters? So very briefly, to contract out to the 1954 Act, as Bill touched on, parties can agree to remove the security of tenure benefits from a lease, but it involves the service of various notices by landlord on tenant, and the tenant signing a staff deck. And in the old contract out procedure, it also involved an application to court to get it rubber stamped. These agreements were all pretty dated. So the first one there, Saddleworth Golf Club on the left of the slide, the agreement did refer to it not creating a landlord and tenant relationship. So this goes back to my point about they were trying to create a license, clearly. But in any event, the parties, out in abundance of caution, decided to contract out or attempt to contract out by serving notices, and they confirmed that T-Mobile, the tenant, agreed that it wouldn't have protection of the 54 Act. Usually, those type of clauses are much more prescriptive than that. They have the date the notice was served, they have the date the tenant signed the declaration. They're just much clearer. So is that good enough, was the question for the court. The second one was an older agreement, and it dealt with the old contracting out procedure. And as you can see there, it's got reference to the court order granting the contracting out. Is that enough? It doesn't refer to there being an agreement between the parties. It just references the court order. The court didn't really have the power to exclude. All the court did was confirm that the parties had done everything they needed to do and effectively rubber stamp it. So was that wording good enough? Ultimately, yes. The court took a very pragmatic approach and said they were both fine, taking the wording, the usual wording from the Saddleworth, confirming that it wouldn't have security of tenure. Ultimately, the judge was satisfied that all the wording taken together would amount to agreement under the statute. The substance was there, the parties had done what they needed to do. Yes, it wasn't referenced to dates, etc., but the court felt that it was clear from any third party reading the lease or acquiring the interest that agreement would not have security of tenure, and that's what the idea of the clause in the lease is. Similarly, in the Taunton Farm matter, the old contract note, it referred to everything it needed to. It done its job. Its statutory job is to make sure that the parties are aware, or any third parties are aware, that this agreement does not have security of tenure. Put there at the bottom, there was 3 other agreements as well that this decision dealt with. The operator, AP Wireless, acquired those 3 interests many years after the notices were allegedly served on the old tenants. So what they've done is put the landlords to strict proof that the notices and declarations had been served. Given that it was many years ago, the landlords couldn't produce evidence of the notices. They just didn't have them. And the judge, upon considering everything before them, said on the balance of probabilities, he was happy the notices had been served and the declarations made. He said the reason that the clauses are in there, the contract out clause in the lease, is to record all the important information in the principal document, i.e. the tenancy. And he went on to say there's no requirement for the notices and declarations to be kept. Their function's been fulfilled and their existence is noted in the clause or the endorsement. So there you go. In terms of takeaways, I'll stick to standard drafting. All the precedent clauses nowadays, I know these were older tenancies, but there are standard clauses in the precedents that deal with this. They have very clear clauses that have all the relevant details. There's date of service, the date of the declaration, the person who made it. If you are intending to contract out, don't use bespoke clauses. Use the very simple, clear clauses that are in place, because mistakes were made when the process was new. And finally, I've said retain evidence. Although the judge said there's no requirement for the notes to be kept, and that inevitably documents will be lost amidst all the deeds, etc., on the conveyancing file, but I feel losing crucial documents like that shouldn't really be easily excused. keep them with the lease, ideally, keep scan copies with the lease. Yes, I know hard copy deeds packets aren't as common anymore, but the evidential burden may not be easily satisfied if it was a landlord and tenant, same parties, and the tenant denies ever receiving the contracting out notice and denies making the declaration. If you as landlord then can't prove that you did serve, you could be on a sticky wicket. And thinking long term, any purchases when you're acquiring these sites, ask the question for these notices. Yes, they might not have them, but you can try and satisfy yourself that the process has been properly undertaken before acquiring the interest. And that now is my last slide. So that takes us to my colleague, Jay Mehta, who's going to go into the interesting topic this morning, competition law and how it relates to real estate transactions. Jay?
Yes, thank you, James. And good morning, everyone. My section highlights the intersection between competition law and real estate. So just to set the terms of reference, the frame of reference, I would take real estate as being defined as the transfer or grant of rights or interest in or over land, and competition law as being the regulatory regime that deals with artificial distortions of the market. The oversight that competition law has is normally with the Competition and Markets Authority, but where competition law overlaps with national security, the Cabinet Office now has oversight over these issues. How competition law intersects with real estate depends very much on the parties to the transaction. Where the parties to the transaction involve a public body, and where the parties to the transaction are both private sector bodies. Where parties to the transaction involve a public sector body, the following competition law considerations arise. The first is the obvious one of a transfer or grant of land to the private sector party at an undervalue. So this is where, let's say, a local authority transfers a site to a private sector developer at an undervalue. So the first consideration is naturally Section 123 of the Local Government Act 1972, which requires that land is transferred by a local authority for best consideration, sort of equates to market value. There is a general disposal consent which allows, in certain circumstances, land to be transferred at an undervalue. But as soon as that happens, you trigger something called subsidy control. Now, subsidy control is a regime that is set out in the Subsidy Control Act 2022 and its associated statutory guidance. The premise behind the Act is to follow European state aid laws, which used to apply before Brexit. And that is that where the state involves itself in the market on a subcommercial basis, it has to justify why it is doing so, either by self-assessing this as reasonable using a set of principles, or by fitting within a certain type of exemption called a streamlined subsidy scheme or minimum financial assistance. Otherwise, there is an illegal subsidy in terms of the undervalue to the transferee of the land. And essentially, that, if challenged, that would need to be paid back to the public authority. So a very good example of that was discussed very recently in the Renneker case, where a loan was made for a house developer to obtain a site and build residential accommodation over it. And a competing developer challenged this in the Competition Appeals Tribunal. Fortunately, it was held that the loan was not at a sufficient degree of undervalue to warrant a subsidy arising. And essentially the case was thrown out and appeal was denied. But this is where real estate transactors need to be very wary, either land being transferred at an undervalue or where there is a grant or loan on sub-commercial terms offered to a developer to acquire a site, whether at under or market value. All of these can constitute subsidy to the developer. A developer needs to be wary that the public authority is performing its functions of assessing the reasonableness of any subsidy that arises. Another area where competition law would apply to land transfers is where the transfer or grant of land is made with conditions attached. So if you have a transfer, you have a development agreement attached to it, for instance, or if you have a grant of a tenancy, there are abnormal tenancy requirements. I'll explain both in a bit. In terms of the first case, where you have a grant of land, which is then attached to a development agreement, you may reach a situation where the public authority's authority over the development is decisive. It exercises a decisive influence over what is built on the site. This can be either now or it can be in the future, for instance, where a developer is given an option to draw down a site, but once it does draw down the site, then it is incumbent on it to actually perform some development activity. So this was an illustration of what happened in the Faraday case. And in the Faraday case, basically, even though the obligations were deferred until the developer actually exercised its option to acquire the site, it was still held that it would be an anticipatory breach of procurement law because it would constitute a works contract rather than simply a land disposal contract. So just to provide the basic setting, an ordinary transfer or grant of land is not something that needs to be procured. However, if conditions are attached to its transfer that makes it into a works contract, or as can be seen in the Ocean, Outdoor and Hammersmith case, a services contract, then you might have either a works or services contract being implied. That is the main purpose of the contract itself, and it might become a procurable contract if it is over a certain threshold in value. In relation to grants of tenancies, if there are abnormal tenancy requirements, and again the Ocean Outdoor and Hammersmith case illustrates that, if there are abnormal tenancy requirements, it's not the sort of thing that you would see in a tenancy lease. So the tenant has to perform a huge number of works where the landlord exercises a decisive influence, and basically the tenant has a legal obligation to perform those works or perform services, for instance, management of the property, etc. In either of these cases, where there is a contractual liability to perform works and services that go beyond the normal what you would normally see in a tenancy agreement, then beware even the grant of a lease might involve a procurable contract in very much the same way as the transfer to a developer would, as previously discussed. Other types of public sector involvement can also include subsidy. For instance, as we discussed with the Renneker case, the grant of a sub-commercial loan to a house builder was challenged as being an illegal subsidy to the extent of the discount to market in the return of the loan. However, the case actually went further to discuss whether the entire loan could be treated as a grant on the basis that, given the gearing vis-a-vis the same creditor, uh, whether an ordinary financial institution would have actually made a loan in the same way as the Greater Manchester Combined Authority had provided to Renica. Fortunately for the Combined Authority, both points were dismissed because it was held that the Combined Authority carried out relevant due diligence processes in assessing the interest rate and the gearing of the loan. This is generally done using complex banking regulation guidance, such as loss given default ratio and other aspects of the Basel Convention. Another aspect of subsidy control that arises is where direct grants are made. For instance, you might have heard about the cladding funds that are provided to proprietors of real estate rather than the tenants and the occupiers. These are grants that are provided to proprietors who can be businesses, who are landlords or property managers, and they are tasked with the job of providing cladding on buildings that are occupied by tenants. It's very clear that tenants should not have to pay for these cladding enhancements. And I think everyone knows the background to this, being the Grenfell, the unfortunate Grenfell disaster. These grants would, based on government guidance, constitute subsidies to the landowners because the landowners are acting as businesses. So they would have the public authority would have to justify the grants to the landowners as being a subsidy that has been properly provided. Another area in which subsidies would arise would be where grants are provided by local authorities and central government in some cases, or even sub-commercial loans, Green Deal, etc., where there are environmental issues like retrofits on residential accommodation. So, solar paneling, insulation, air source heat pumps, groundwater heat pumps, that sort of thing. There are other types of public sector involvement where real estate can coincide with subsidy control. For instance, tax breaks in tax havens. Now, we're not talking about the more exotic tax havens like Aruba, etc. No, we have tax havens right on our doorstep. Free ports, enterprise zones, these are all tax havens. They provide a massive number of tax discounts and deferrals and exemptions. And they also allow for grants, infrastructure grants, etc., that benefit businesses that are located in these areas. And subsidy control issues arise, and hence competition law issues arise in these situations as well. In this slide, we discuss competition law issues arising on the flip side, where both parties are to the real estate transaction are private sector parties, and hence there's no public authority involved. The first subsidy control, the first competition law issue that arises is merger control. Now, one would expect merger control to apply when one company takes over another. But not necessarily. Merger control can also apply where a company acquires a material influence in the assets of another company. So it's basically on an asset sale. So an asset sale generates merger control issues if the consideration paid for the collection of assets is higher than the fair value of the asset itself. And this is generally where you have a provision for goodwill. The provision for goodwill is made in accordance with the provisions relating to accounting for goodwill and fair value in FRS 102. Once the goodwill is ascertained vis-a-vis the potential turnover of the group of assets the current and projected turnover of the group of assets, this is generally accounted for in the balance sheet of the acquirer as such. Merger control issues can arise in these sorts of circumstances. And a classic example is Section 23(2) of the Enterprise Act 2002, where if the merger relates to assets where there is a shared supply, for instance, you can have a company that owns a chain of pharmacies, acquiring another company, the assets of another company, that a group of pharmacies that are hived down, and these coincide in terms of geographical access or in terms of the market share, in terms of customers, etc., with the acquiring company's pharmacies. In these sorts of circumstances, there might be an overlap in the supply that is provided by the two businesses, and if then either one of the turnovers, either of the acquiring company, the UK turnover of the acquiring company, or the UK turnover of the group of assets that is acquired, and as noted, that can be ascertained through the balance sheet assessment of goodwill. Either of their the UK turnovers exceeds 10 million, you are brought within merger control jurisdiction. There are various other tests in Section 23 of the Enterprise Act, but the one I tend to deal with most often are the safe harbor tests that I've just mentioned. The other area in which you can have competition law applying to a private-to-private transaction is under the restrictive practices. This is under the Competition Act, not the Enterprise Act now anymore. It's Competition Act. So in relation to restrictive practices, so you can often in a landlord and tenancy agreement, for instance, you can often find non-compete clauses, for instance, restrictive covenants in leases. One example is where the landlord asks the tenant not to compete with it. So the landlord owns a store. It leases part of the premises to a tenant, and it's asked the tenant that when it sets up its own store, it doesn't compete with the landlord's activity. Another example is where the tenant asks the landlord to ensure that the landlord doesn't let out adjacent sites to the demised premises to competitors. And a good example for this are the cases under the Groceries Order 2010. So I think the full form is called the Groceries Market Investigation Control Land Order 2010. And in 2020, Tesco, and in 2025, the Co-op were brought up in front of the Competition Markets Authority because they stipulated in their tenancy agreements with their landlords precisely this, that they didn't want tenants that competed with them in the near vicinity. So the landlord was restricted from providing tenancies to them. Remember that restrictive practices can arise beyond just the groceries provisions. The groceries cases are good examples of them applying. Other areas in which restrictive practices can apply is where there is a price fixing. So you're kind of going like a cartel style arrangement. So this could be where two adjacent landowners fix rental prices so that they don't undercut each other. A lot of Competition Markets Authority investigations have arisen in relation to price fixing in the real estate sector. A classic example is price fixing relating to estate agents. So estate agents were sharing information and price fixing in relation to their interface with sellers and buyers of residential real estate, and also residential house builders who were fixing prices amongst themselves and also exchanging confidential information about current and future prices amongst themselves so that they could reach par or minimum price arrangements. Remember, These price fixing arrangements do not have to constitute formal contracts. They can constitute informal arrangements. So obviously, in these circumstances, it's harder for the Competition Markets Authority to pick these up. But they are saying that they have AI processes which can pick up Doppler effects in the pricing market in particular areas. So they are asking lawyers to tell clients to beware and to train clients to essentially beware of restrictive practices and also bid rigging, for instance, price fixing and bid rigging in such markets. Another example of a price fixing case is the interesting case of Heathrow Airport and Sofitel Aurora, where Heathrow Airport, being the freeholder, leased part of its premises to Sofitel Aurora to operate a hotel. Sofitel Aurora was fixing cab prices, taxi ride prices that were lower than the taxi ride prices that Heathrow had fixed. And Heathrow coerced basically Sofitel Aurora to increase its cab hire prices so that it would not undercut Heathrow. And as a consequence, the Competition Markets Authority said, no, that's a price fixing cartel arrangement. Remember, if it is a cartel arrangement, it's regarded as what's called a restriction by object clause. You don't have to look at its market effect. You don't have to look how strong the players are in a market to be able to assess whether it's whether it's banned or not. It is just so egregious that it would be forbidden per se, as they call it in the States. A good example of very powerful price fixing is where we talk about abuse of dominant position. Now, this is relatively rare in cases outside of controlled areas like harbors and ports, etc. So within the harbors and ports, for instance, the charging out of real estate has to be done very carefully, because you've got the Harbors Act on the one side, it's the Harbors Act 1964, and then you've also got the abuse of dominant position on the other. Both of them sort of come together in making sure that berthing fees, landing and handling fees, etc., they're not overpriced and deter or set contra favorably to favor certain parties and not the other. Under normal circumstances, abuse of dominant position generally arises in large, complex issues in large, complex industrial estates where you have one landowner that fixes the pricing of others. You generally take a pragmatic view, and you do what's called the 10-minute taxi ride around the estate. Just wander around to see if there are any competitors, either to the tenant or to the landlord in these sorts of circumstances. Just see whether there is a potential abuse of dominant positions, either in industrial estate or in an enterprise zone or in protected areas like airports and ports or free ports, etc. There is some discussion about whether the issue of ransom strips could be brought within competition law, particularly in the more enhanced Competition Markets Authority remit relating to consumer protection. Under normal circumstances, there are rules of thumb based on real estate case law in relation to the sharing, to the consideration for a ransom strip being limited to, let's say, a third of the profits made by the buyer of the ransom strip eventually. And whether abuse of dominant position provisions could apply if it went above the accepted limit in these sorts of circumstances. It's still very much in the air. I can't tell you for sure whether ransom strips are going to form the basis for Competition Markets Authority investigation. But it's certainly, these are certainly the sort of things that the CMA is starting to look at the moment. In this slide, I'd highlight the additional competition law issue arising where national security is involved in a land transaction. It's still treated as a competition law issue, even though it involves national security, as its terms, like definition of material influence, etc., mirror that of other competition law provisions like the merger control, and also the legislation we're discussing at the moment, the National Securities and Investment Act, or NSIA. 2021 used to be within the remit of the Competition Markets Authority before it was moved to the Cabinet Office. Very broadly, the legislation is brought into play where land is used for a sensitive activity. So the sensitive activity generally, the three main sensitive activities are defense, export control order, that's for military and dual use purposes, or critical supplies to the government. So if you've got a defense facility or a nuclear site on the land that you are actually conveying, or your land is adjacent to such a site, very, very close by, certainly, you might have a security issue arising. Although the parties to the real estate transaction could both be overseas, the land itself will give you a nexus within the UK for you to have to seek clearance. Well, recommend that you seek clearance before the land is actually transferred. I say recommend because if you are simply transferring rights or interest in land, there is no mandatory notification requirement to the Cabinet Office in order to transfer an asset. However, if there is a national security issue involved, the Cabinet Office will generally call something like this in. And to avoid that, you make what's called a voluntary notification. However, if you have one real estate company acquiring another real estate company, then you might have a mandatory notification under the NSI Section 14. As I said, realistically, you have defense, nuclear, military, and dual use critical supplies to the government sort of activities carried out in the land or on adjacent land being subject to this regime. But it could also involve areas where you're performing research in sensitive areas, for instance, synthetic biology, artificial intelligence, that sort of thing. You can have activities like that being carried out on the site, which then become potential national security issues. And that essentially brings me to the end of my section. I'm going to go back to the floor now to Bill in order to take questions from the audience.
Thank you very much, Jay. I'd invite you, Jay, to stay on camera, and I'd invite James back onto camera. We've got 10 minutes or so to see how many questions we can rattle through. We've had a number of questions covering all three talks. There's two questions on upwards only rent reviews, so I'll pick those ones off first. First question from Philip Duggleby. Will an existing upwards only rent review clause continue via the renewal of a protected lease, or would it disappear as part of reasonable modernisation? It's a great question, Philip. Thank you for that. So as I've said, this only affects new leases. So the existing lease, the upwards only rent review clause, still effective. But when that lease is renewed, assuming that lease is renewed under the 1954 Act or by negotiation, then the renewal will be caught by the Act, because the new provisions would apply where the lease is granted after the schedule comes into force and is not granted under a contract entered into before the schedule comes into force. So if the clause is repeated in the renewal lease, it will have no effect on a lease renewal, on a rent review under the renewal lease, provided that the renewal lease is a business tenancy at the time of review. The question then of will it disappear as part of reasonable modernisation? Yes, if the lease is repeated, with the upwards only rent review clause, if the upwards only bit is likely to be ineffective, will a tenant therefore argue on renewal, well, actually, the lease renewal should not include the upwards only clause, reasonable modernisation, because the law says it's of no effect? Landlord might counter that by saying, yes, but it's only of no effect for so long as the lease is a business tenancy. Therefore, I still want it in so that I get the benefit of it if the tenant has vacated or sublet by the time of renewal. So I think that would be an interesting discussion. But in principle, the basic position is that the upwards only review clause, even though effective in the existing lease, will not be effective in the renewal lease. What I would add to that is that, of course, we are looking here at the bill as introduced into Parliament. It is likely and indeed probable that even if this schedule survives and the ban happens, that the clauses will be tweaked one way or another. So we'll have to see how it ends up. And then the second question on upwards only rent reviews was from Rachel Sharp, asking, will the tenant's ability to trigger rent reviews only apply in new tenancies? Great question, Rachel. The answer is yes, because the whole Schedule 31 starts this schedule applies to a tenancy if conditions A to D are met. So the ability for a tenant to trigger a rent review or force a rent review through, where the lease reserves that power only to the landlord, will only apply to new leases. And the reason that's significant is because most modern leases aren't so onerous. So they do allow the tenant to take action. So the problem mostly arises in older leases, but the tenants under those leases will not be able to take advantage under the legislation as currently proposed. So yeah, great questions and points there to keep an eye on as the bill progresses. Right then, a question for James, and this question is from Chris Threlfall, and this relates to the Trocadero case. He says, when a tenant is paying a contribution to insurance under protest, is it sufficient just to include without prejudice on the related correspondence? So that's one for you, James.
I'd include a little bit more. If you look at the decision itself, paragraphs 177 to 187, the judge actually repeats the wording used by the tenant in that matter. The second lot of wording is better. I think the solicitor drafted. It refers to the payment being made strictly without prejudice for the tenant's right to seek recovery of the same in the event that it's not recoverable for one reason or another. So I wouldn't just put without prejudice on your letter or correspondence. I'd include a covering email or letter when you're making payment, and makes it clear that yes, you're paying it, but you reserve your right to pursue recovery in the future in the event that the lease clause does not permit it, for example. Yeah, that's it really on that one. Oh, looks like Bill may have frozen. So there's a second question in there directed at myself in respect of the Pridewell case. So I'll pick that one up for the moment. And it said, could the landlord have taken steps to compel the tenant to allow access for the acoustic survey? The short answer is no. The reservation within the present tenancy only allowed the landlord and its workmen to enter to undertake repairs, alterations to the demised premises or adjoining property. Conducting an intrusive acoustic survey didn't fulfill that definition. And if you are pursuing more, if the tenant refuses, as a landlord, you'd have to pursue an injunction to sort of force access. The courts are very reluctant to do that unless the clause is very clear. So in this matter, the clause was quite narrowly construed, and also it would have been a breach of the quiet enjoyment obligations within the lease. So that sort of ends that point. Now, Jay, there are a number of questions for yourself. So incoming. So the first one, Jay, is if the land is transferred to a developer at market value, but the local authority do not impose a Section 106 agreement, will the lack of a 106 agreement be regarded as a possible subsidy?
That's a good question. The answer is most likely not, because as was decided in the Durham waste disposal case, uh, 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 where there is you're within the performance of a statutory power or statutory discretion or statutory duty, you will not automatically create a subsidy unless you have essentially unreasonably exercised the discretion, etc. And that's why the giving of a subsidy in terms of a grant, etc., needs to be justified as reasonable unless it is exempt from doing so. So if you Section 106 is a discretionary power that local authority wields. If it validly decides not to exercise the Section 106 power, and it is validly within its statutory powers to do so, within its statutory remit to do so, then it's unlikely that that will involve a subsidy. Someone challenges that, says, well, that was unreasonably, for a similar development, we had a Section 106, and why didn't they? And if the local authority cannot then justify that, then we might have a subsidy issue there. Yes.
Great. There's actually another question from Sean Hackett, so brace yourself, Jay, quite incoming.
All right.
If a landlord wishes to regulate the user mix in an estate, secures an anchor tenant, and then they agree to rent premises in the estate to another competitor, how likely is that covenant to be found to be void in that context?
Well, I mean, that's your classic non-compete that we were discussing earlier. However, not all non-competes will be are examinable and avoidable by the CMA. You can have a non-compete that is justified through public policy, etc. So I'll give you an example. You can have a high street that's got loads and loads of tenants that are pubs. And the landlord, which is the council, basically says, I don't want any more pubs here. So can we have something else? Can we have a grocery store? Can we have an art gallery or something like that? Although it's a restriction, it's a non-compete there. The basis for the landlord actually making the stipulation is to provide a more varied experience, a more fulsome experience to the public footfall within the high street. So if, therefore, the landlord is regulating the user mix, as the first line of your question says, if the landlord is regulating a user mix, if it is justified in creating a variety itself, particularly if it is a local authority following public policy, or the head tenant following local authority policy, in these sorts of circumstances, you could say that the restriction is ancillary to the overall purpose of what the landlord is trying to achieve, and it need not necessarily constitute a non-compete that is potentially voidable. On the other hand, if the non-compete is there for the anchor tenant to ensure that it remains the top dog in that particular area, we could be looking at, it depends very much on how big the market share is, etc. What sort of market we're looking at. Remember, it's not a cartel agreement per se. You're not price fixing or bid rigging or sharing the market out or splitting the market out. So you might be, depending on the restriction. So you do have the market test available to you as to how significant your market share is in that particular market and how much the restriction is going to apply to the local competition in the area. So it's quite a loaded question. It's something that we can discuss relating to the particular circumstances of the case. But broadly, this is kind of the approach I would take to this.
Thank you very much, Jay. Right, well, I promised we'd get you on your way by 11:30, so I'm going to bring matters now to a conclusion. I'd like to thank once again, my fantastic co-speakers, James and Jay. I'm particularly grateful to James for picking up the Q&A duties when my connection dropped off just now. I'd also like to thank Diane and Ruby and our brilliant events team who make these events happen. But most of all, a massive thank you to all of you who have given up your time to join us today. I hope you've heard something of interest. Apologies to those we didn't have time to pick up your questions. But we hope to see you again soon, and we hope that Hill Dickinson can be of service to you soon. So have a great day, everybody, and goodbye.